Imagine this, you're chatting with a coworker about your paycheck. Maybe you're comparing hourly rates or wondering if you're being paid fairly. Suddenly, your manager overhears and says, "You shouldn't be talking about pay here. If you keep it up, you could lose your job." That leaves you wondering, can my employer actually fire me for talking about my salary? Here's the truth. In most cases, the answer is no. Federal law protects your right to discuss wages with coworkers, and many states have passed pay transparency laws that go even further, making it illegal for employers to punish workers who talk about pay. But, like most workplace laws, there are a few exceptions and limits. In this video, I'll explain why salary discussions are protected, what laws apply, and what you can do if your boss threatens you for bringing up the subject. Part 1. Federal protection under the NLRA. The main law that protects your right to talk about pay is the National Labor Relations Act, NLRA, passed in 1935. This law applies to most private sector employees, whether or not you belong to a union. Under the NLRA, workers have the right to engage in concerted activities for the purpose of collective bargaining or mutual aid and protection. That means you and your coworkers can legally discuss wages, hours, and working conditions in order to improve them. Talking about your salary isn't gossip. It's a protected activity. For example, if you and a coworker compare paychecks and realize one of you is underpaid, you might decide to approach management together. That's exactly the kind of mutual aid the NLRA is designed to protect. Your employer cannot legally fire, discipline, or retaliate against you for these discussions. This protection is why many pay secrecy policies in employee handbooks are illegal. If your company has a rule saying employees may not discuss wages with one another, that rule violates the NLRA. The National Labor Relations Board, NLRB, which enforces the law, has repeatedly struck down such policies. But there are limits. The NLRA doesn't cover supervisors, managers, or certain public sector employees. If you're in one of those roles, the protections may not apply. Also, the law protects honest conversations about pay, not situations where you disclose confidential information you weren't entitled to see, like other employees' salaries from HR files. It's also important to understand that while the NLRA protects the right to talk about pay, it doesn't prevent employers from reacting negatively in other ways. For instance, your boss might not like the conversation, but they cannot legally fire you or discipline you solely because of it. If they do, that's considered unfair labor practice, and you can file a charge with the NLRB. So, under federal law, the short answer is, if you're a covered employee, you have the right to discuss your wages with your coworkers, and your employer cannot fire you for it. Part 2. State pay transparency laws. While the NLRA gives broad federal protection, many states have gone further by passing pay transparency laws. These laws not only make it clear that workers can talk about wages, but also often require employers to be more open about pay ranges in job postings and promotions. For example, California has one of the strongest transparency laws. Employers cannot prohibit employees from discussing or disclosing their own pay, and they must provide pay scales for job positions upon request. Starting in 2023, California also requires employers with 15 or more workers to include salary ranges in job postings. New York has similar rules. The state bans retaliation against employees who discuss wages, and as of 2023, employers are required to list pay ranges in job advertisements. This helps prevent wage discrimination and gives workers clearer information when applying for jobs. Colorado passed the Equal Pay for Equal Work Act, which requires employers not only to share pay ranges, but also to notify employees of promotional opportunities. Workers there have the right to discuss pay openly without fear of punishment. Other states with strong protections include Connecticut, Washington, Nevada, and Massachusetts. These laws ensure that employers can't discipline or fire workers for discussing pay, and often impose fines for violations. Pay transparency laws are spreading quickly because of the push to close the gender pay gap. Studies have shown that when wages are kept secret, women and minority workers are more likely to be underpaid. By making pay discussions legal and even encouraging salary posting, these laws aim to level the playing field. But even in states without explicit pay transparency laws, remember that the National Labor Relations Act still applies to most private sector employees. That means you already have a baseline right to discuss wages. State laws just add extra teeth by giving workers more tools and clearer rights. The takeaway is this: depending on your state, not only is it legal to talk about your salary, but your employer may be required to provide more pay information up front. If your boss threatens you for talking about pay in California, New York, or Colorado, they're not just violating federal law, they're breaking state law too. Part 3. Exceptions. When salary discussions may not be protected. Even though federal and state laws protect most workers who discuss wages, there are some important exceptions and limits you should know. First, the National Labor Relations Act, NLRA, doesn't cover everyone. Supervisors and managers are excluded, meaning if you have the authority to hire, fire, discipline, or make significant decisions about other employees, you may not be protected in the same way. Employers often argue that managers discussing salaries isn't concerted activity under the NLRA. Second, the law protects your right to discuss your own pay and working conditions, but it doesn't give you the right to access or disclose confidential payroll data. For example, if you hack into HR files or share other employees' private salary information that you weren't authorized to see, that could lead to legal discipline. The protection is about open conversations, not misuse of confidential records. Third, certain public sector employees, like government workers, may be covered by different rules. Some have protections under state civil service laws or union agreements, but they aren't always governed by the NLRA. That said, many government employers still recognize employees' rights to discuss pay. Fourth, context matters. The NLRA doesn't protect discussions that cross into harassment, threats, or disclosure of trade secrets. For instance, you're free to say, "I make $20 an hour, and I think we deserve more." But if the conversation involves offensive remarks or sharing confidential client pricing data, the employer may take disciplinary action without violating the law. Another wrinkle: while the NLRA protects concerted activity, purely individual complaints aren't always covered. If you only complain privately to your boss about your salary without connecting it to coworkers' concerns, it might not count as protected activity. But the moment you raise the issue collectively, like discussing with colleagues or suggesting improvements, it usually is protected. Finally, employers sometimes try to create the impression that talking about wages is unprofessional or against company policy. Even if such a policy is written in your handbook, it doesn't override the law. The NLRB has struck down many of these rules as unlawful. Still, employees should know their rights, so they don't get intimidated into silence. So, while most private sector employees are fully protected when discussing pay, managers, misuse of confidential data, and certain contexts can limit those protections. The key is knowing when your conversation falls within the safe zone of lawful activity. Part 4. Consequences for employers who punish pay discussions. When an employer punishes or fires workers for talking about wages, they're not just breaking a rule, they're violating federal labor law. And the legal consequences can be significant. Under the National Labor Relations Act, NLRA, retaliation against employees for engaging in protected concerted activity, like discussing pay, is considered an unfair labor practice. The National Labor Relations Board, NLRB, can investigate and take action. If they find your employer violated the law, they can order remedies such as reinstatement. If you were fired, your employer may be required to give you your job back. Back pay. Employers often must pay the wages you lost between your firing and reinstatement. Policy changes. The company may have to rewrite illegal pay, secrecy rules in handbooks, and train managers. Notice postings. Employers can even be required to post signs in the workplace, admitting they violated the law and promising not to do it again. For employers, the reputational cost can also be high. Being found guilty of wage secrecy violations undermines trust with workers, invites union organizing, and may draw media attention. In states with pay transparency laws, the penalties can be even tougher. For example, in Colorado, employers who retaliate against employees for discussing pay can face fines and damages. In California, workers denied their pay, transparency rights can sue for monetary damages and attorney's fees. These state laws give employees direct tools to hold employers accountable in court, not just through the NLRB. There's also a broader economic consequence. When employers silence pay discussions, they risk perpetuating pay discrimination. Courts have recognized that hiding salary information often leads to women and minority workers being underpaid. That's one reason why federal and state governments have been so aggressive in enforcing transparency laws. It's worth noting that retaliation cases are not rare. The NLRB receives thousands of charges each year related to pay discussions, and many result in settlements where employees are compensated. The message is clear. Employers cannot legally punish workers for talking about pay. If they do, they may end up not only reversing the firing, but also paying significant damages. Part 5. What workers should do if they're punished for talking about pay. If your boss threatens you, disciplines you, or even fires you for discussing wages, don't panic. You have rights and clear steps to protect yourself. First, document everything. Save emails, text messages, or notes from conversations where your employer discouraged or punished pay discussions. Write down dates, times, and what was said. If coworkers witnessed it, ask if they'd be willing to confirm what happened. Documentation is your strongest defense. Second, review your company policies. If the handbook has a no pay discussion rule, that policy itself may be illegal. Take a copy if you can. It could become key evidence in a complaint. Third, file a charge with the NLRB. If you're a private sector, non-supervisory employee, the National Labor Relations Board enforces your right to talk about pay. You can submit a charge online, by phone, or at a local office. The NLRB will investigate, and if they find your employer violated the law, they can order reinstatement, back pay, and policy changes. Fourth, check your state's pay transparency laws. In states like California, New York, Colorado, and Washington, retaliation for wage discussions can also be challenged in state courts or labor departments. These laws often allow you to recover damages and attorney's fees. Fifth, consider legal advice. Employment lawyers can help you understand your options, especially if multiple rights were violated. For example, if you were also denied overtime or discriminated against. Many lawyers work on contingency, so you don't pay unless you win. Lastly, remember, employers cannot legally retaliate against you for filing a complaint. If they try to blacklist you, cut your hours, or harass you for asserting your rights, that creates a second violation. Real-world cases show workers do win. For instance, retail employees in several states have been reinstated with full back pay after being fired for discussing wages. These outcomes send a strong signal. You don't have to stay silent, and the law is on your side. The key is to act quickly, keep records, and use the protections available. Talking about pay isn't misconduct. It's a legally protected step toward fairness. So, can your employer fire you for talking about your salary? The answer is almost always no. Under the National Labor Relations Act, most private sector workers have the right to discuss pay as part of concerted activity. And with new state pay transparency laws, spreading across the country, your protections are even stronger. Employers who try to punish or silence these conversations risk serious legal consequences, from reinstatement and back pay to lawsuits and fines. If you're ever threatened or disciplined for talking about wages, remember, document what happened, check your rights under both federal and state law, and don't hesitate to file a complaint. Salary transparency isn't just legal. It's one of the best tools workers have to ensure fairness and close pay gaps. If this video helped clear things up, hit like, share it with your coworkers, and subscribe for more plain English guides to workplace law. And tell me in the comments, do people at your job talk openly about pay?